welcome to 5-Minute Family Law. Today, I'm going to be providing an introduction to the division of property and debt in British Columbia. If you qualify as a spouse, you are entitled to ask for an order for the division of family property, family debt, and sometimes something called excluded property under the Provincial Family Law Act. Now, you'll recall from past episodes that there are 3 categories of relationship that qualify as spousal under the Family Law Act. There are firstly people who are married or used to be married to each other. Secondly, there are people who are unmarried but have lived together in a marriage-like relationship for at least 2 years. And then thirdly, there are people that have lived together in a marriage-like relationship for less than 2 years but have had a child together. That third category of spouse does not qualify for the purposes of the division of property and debt under the Family Law Act. So, to ask for an order under the Family Law Act, you have to have either been married to your partner or you have to have lived with them in a marriage-like relationship for at least 2 years. Now, if you don't qualify as a spouse, you can't ask for an order for the division of property under the Family Law Act, but you're not entirely out of the woods. I'll talk about that in a second, but for now, let's talk about the ins and outs of applying for the division of property and debt under the Family Law Act. The basic idea about the division of property under the Family Law Act is pretty straightforward. Basically, you get to keep what you have going into the relationship, but you have to share in the things that you and your spouse acquire after you've started the relationship. And so we're talking about 2 baskets. One basket of property is family property, and that's the stuff that you have to share. And the presumption is that you each get a 1/2 share of the property. And then there's the other basket of the things that you get to keep, and that's called, under the Family Law Act, excluded property, and that is presumptively the property of the person who owns it. You don't have to share it. So, in a little more detail, the way it works is this. The property that you have on the date the relationship begins is yours. Now, the date the relationship begins is the earlier of the date that you get married or the date that you begin to live together, whichever is first. So all the property you have until the date that you begin to live together or marry is yours. What you have to share in is the property that you acquire during your relationship after that date, all the way up to the date of separation. Now, of course, it's not quite as simple as that, because there are other property that you might get during the relationship which also falls into the basket of excluded property. And generally, what we're talking about are gifts and transfers of money from third parties. So we're talking about insurance proceeds that are for your own injury or your own loss, court awards that are for your own injury or your own loss, gifts that are personal to you that you have received from a third party, like a parent, or inheritances that are personal to you that you receive from a third party, like your parents. All that stuff is all part of the excluded property. The family property is composed of not only the property that you acquire between the beginning of the relationship and the date of separation, it's also the growth in value, if any, of your excluded property. So let me give you a super simple example. This blue arrow represents the passage of time. At some point in the past, you and your spouse moved in together. Eventually, you got married, and then eventually you separated. But long before you moved in together, you bought a house and you paid $150,000 for it. But it grew in value so that by the time you moved in together, it was worth $200,000. The house continued to appreciate, and by the time you got married, it was worth $225,000. By the time you separated, it was worth $300,000, and today it's worth about $325,000. However, what you have to share is the increase in value between the date you moved in together and the date that you separated. And as a result, the value of the house and the date that you got married doesn't really matter. Neither does the current value of the house, and neither does the amount that you paid to buy the house. What you're sharing is 1/2 of the increase in value, or, from your perspective, $50,000. So here's the math. You have to pay $50,000 to your spouse, which is the increase in value between the date that you moved in together and the date that you separated. You, on the other hand, get to keep $200,000, which was the full value of the house and the date that you moved in, plus half the growth in value. And on top of that, you also get to keep all of the growth in value after the date of separation. Let's take a different example. In this case, let's talk about an inheritance that you received during a relationship. When you received the inheritance, you received $10,000. By the time you separated, it was worth $20,000, and thanks to an incredible rate of return, it's now worth about $25,000. And again, what you're sharing is the increase in value of the inheritance between the date that you received it and the date of your separation. And as a result, the value of the inheritance now really doesn't matter. So you have to share 1/2 of the increase in value, and here's the math. $5,000 goes to your spouse, which is 1/2 of the increase in the value between the date that you received the inheritance and the date that you separated. You, on the other hand, get to keep $10,000, which was the value of the inheritance when you received it, $5,000, which is half the growth in value after you received it up to the date of separation, and then in addition to that $15,000, you get to keep all of the growth in value happening after the date of separation. All right, super fast recap. Excluded property is all the stuff that you bring into the relationship, plus some kinds of property that you get during the relationship, like inheritances and court awards that are personal just for you. Family property is all the property that you and your spouse get during the relationship, whether you buy it separately or you buy it together. Family property also includes the increase in value, if any, of the excluded property. If you own any excluded property, you are presumed not to have to share it. The family property, on the other hand, is presumptively split equally between you and your spouse. Family debt is presumed to be shared equally between the spouses, just the way family property is. Under Section 86 of the Family Law Act, family debt includes all financial obligations incurred by a spouse during the period beginning when the relationship between the spouses begins and ending when the spouses separate, as well as debt incurred after the date of separation if incurred for the purposes of maintaining family property. So a debt that was incurred to maintain family property could be a loan that was taken out to replace the hot water heater or reshingle the roof, or a credit card debt that was incurred to repair the family car. The Family Law Act doesn't talk about why the debt was incurred, just that it was incurred during the relationship. Of course, as you probably expect, there's a lot more to the division of property and debt under the Family Law Act than what we've been able to cover. I'll get into that in future episodes, but in the meantime, the highlights are probably these. First, the value of property and debt is the fair market value at the date of the trial or the agreement resolving those issues. Second, it's possible to ask for an unequal division of family property if an equal division would be significantly unfair. And thirdly, it's even possible to get an order for the division of excluded property that would normally remain the sole property of the other spouse. But like I said, we'll get into that in more detail in future episodes. Something else we'll get into more detail about is what I mentioned at the beginning of this episode about what you do when you have a property claim and you don't qualify as a spouse under the Family Law Act. Well, there's two things to know. Firstly, if you are a co-owner of property with your partner, you have the same rights that any other co-owner of property does in British Columbia. The nature of your relationship's got nothing to do with it. You can ask the court that you be compensated for your interest in the property. You can ask the court for an order that the property be sold and that you get your share out of the sale proceeds. There are other things you can do. If, however, you're asking for a share of property that is not in your name, then you are stuck with the law of unjust enrichment. That's a difficult area of law that everybody finds difficult to deal with, and for lawyers it is almost impossible to give your client a proper opinion that they can bank on. The basic idea with unjust enrichment is that you lost something that your partner benefited from, and there's no legal reason for your loss and your partner's benefit. To take a really easy example, you move into your partner's house and you decide that you're going to renovate the basement. You don't ask your partner to get paid for the labor involved in renovating the basement. It's just something you do because you're in love, and that's what people who are in love do. And of course, your partner doesn't offer to pay you for the same reason. But at the end of the day, you have lost something, which is what you would have been paid for installing a basement in someone else's house, and your partner gained something, and what your partner gained was the increase in value to the property resulting from now all of a sudden having a finished basement that your partner didn't pay for. And so if you can show that there was that loss and the corresponding benefit without any legal reason for the loss or the benefit, you may be able to get the court to find that your partner was unjustly enriched. And the remedy for that, in certain circumstances, is the court finding that you have an economic interest in that property, which sometimes leads to the court imposing a trust relationship called a constructive trust. Now, all of that was very complicated, and like I said, we'll get into that in a lot more detail in future episodes. In the meantime, though, that was the nuts and bolts of dividing property and debt in British Columbia.